All right, good evening, dear colleagues, students, seekers of truth. A very warm welcome on behalf of Normative Orders. I'm Rainer Forst, one of the directors of this research center. Very warm welcome to this very special event, which we're having tonight and tomorrow, which is the continuation of our Frankfurt lecture series, which we had been going on for a long time. And today we have the great honor to host Professor Arthur Ripstein from the University of Toronto. And it's a great delight. Thank you, Arthur, for accepting our invitation and for making these trips. Delight is a word that Kantians wouldn't use. They would speak about enthusiasm. So that's what we feel. The story to be told how we formed the idea to have Professor Ripstein present the lectures this year is brief. For he simply is one of the most important, innovative, and systematic legal and political philosophers of our time. So he was on top of our list, even if this had not been the year in which we celebrate the 300th birthday of Immanuel Kant, though it goes without saying that here in Frankfurt especially, we had to be part of these celebrations, which go on in many parts of the world, and in Germany in particular. And one way in which we honor good old Immanuel is to have Arthur here speak tonight. As you know, Kant's birthday is celebrated all over the world, and in Germany in particular, where Kant has become something like the official Republican philosopher that people look up to. At the birthday celebrations in Berlin that our dear friend Markus Wilaschek co-organized, the great Kantian Chancellor Scholz used the occasion to set Vladimir Putin right about war and peace. It was quite an impressive moment. Now, if there's anyone in the current landscape of philosophy whose reading of Kant's legal and political philosophy is at the forefront of the relevant debates, it is Arthur Ripstein's. Let me start with some bio. He is the University Professor of Law and Philosophy at the University of Toronto, where he holds the Howard L. Beck QC Chair. He has been teaching at Toronto since 1987, so is truly an exemplar of someone who is loyal to an institution with which we're very happy to cooperate in many ways, including a student exchange. And some of the folks here have been to Toronto and benefited very much from this possibility. Of the many honors that have rightly been bestowed on Professor Ripstein, apart from the very rare honor to be named a university professor, let me mention just a few, such as the prestigious Killam Prize from 2021, as well as book awards by the Canadian Philosophical Association for his first book, Equality, Responsibility and the Law, in 2001, then later for Force and Freedom in 2011, and more recently he received the Journal of the History of Philosophy Book Prize for his book Kant and the Law of War. Ripstein is a Fellow of the Royal Society of Canada and a much sought-after keynote speaker, such as today he delivered, for example, the renowned tenor lectures at Berkeley in 2019. Of the numerous important books that he published, let me also mention, apart from the ones just alluded to, his Private Wrongs, very influential book from 2016, and Rules for Wrongdoers from 2019, which are based on his tenor lectures. But two books I need to briefly highlight as we get ready for the lectures today. The first is, of course, Force and Freedom, the magisterial reconstruction and interpretation of Kant's legal and political philosophy. A true masterpiece, as Ripstein manages to bring Kant's philosophy to a systematic life, both with respect to the questions Kant addressed in his time and with respect to the questions that we need to ask in our time, contemporary questions of how to think about the very foundations of law and of political rule. Ripstein locates the core of Kantian thought in a notion of freedom as independence and shows how a whole system of law, private and public, and of politics can be developed on that basis, conceptually and normatively. Given the power of the argument, I'm tempted to say that it is both Ripstein who needed Kant to make this argument in such a forceful way, but no less Kant needed Ripstein to fully explain and for us to understand the systematicity of the Kantian approach. What Ripstein did with regard to the justifiability of a state-based normative order in force and freedom, he also did with regard to international law and international order in this book, more recently, Kant and the Law of War. And could a book be more timely? Unfortunately, I should add, these days. In an ingenious and complex argument, Ripstein shows in this book how Kant's view of the distinctive immorality of war is systematically connected to his views of the norms of right that ought to govern conduct of and in war. And I stop here, as we're all eager to hear Arthur Ripstein's first lecture. It addresses a central concept within Kantian and Ripsteinian thought, the idea of the public. Thanks again for coming over, and the floor is yours.
Thanks so much, Rainer, for that extraordinarily generous introduction. I hope that I will live up to it with today and tomorrow's lectures. What I want to talk about today is, as the title suggests, the idea of the public, and the lecture series is the idea of the public, two Kantian themes. The first of the themes is just what it is for something to be distinctively public. And what I'm going to suggest in developing the Kantian idea of the public is that it has to be understood as distinctively institutional in a certain kind of way, and is characteristic of Kantian concepts, that the only way to think systematically about the public is to think about it contrastively in relation to the kind of wrong that can be done against it. Tomorrow, I'm going to talk about a specific aspect of the idea of the public, that is the idea familiar in the history of philosophy, but explicit in Kantian thought, that the people are capable of ruling themselves through their institutions. There is much that is appealing about this idea and much that is mysterious about it, and I hope to dispel the mystery by clarifying the idea of the public. So that's the plan. So what do I mean by the public? The public is, of course, all around us and completely familiar. And at the same time, it's worth remarking on the ways in which it is distinctive. Think about the differences between the powers exercised by a public authority, such as the government of Germany, and the powers that you or I have as private persons. A public authority gets to do a lot of things, or claims to get to do a lot of things, that private persons are not allowed to do. It gets to collect taxes. It gets to regulate conduct. It gets to impose binding resolution on disputes. It gets to implement various systems of cooperation, define their terms, and then compel people to abide by those terms. These are extraordinary powers. To say that they are extraordinary is not to say that they cannot be justified, but it is to say that they have to be rendered intelligible. Now, what I want to do in thinking about this concept of the public is frame what we can think of as the fundamental puzzle about the public and identify both the Kantian way of framing it and also the Kantian solution to it. So the fundamental problem or puzzle about the public is that these powers seem unique to a public authority. And the key to the Kantian solution will be that that reflects something that is fundamentally distinctive about the public. But let me raise the puzzle, in a particular way. Think about it this way. Think of it in terms of a challenge that children often make to their parents, particularly children who grow up to study philosophy or political theory. That the Stanford philosopher David Hills once said that Philosophy answers questions that come naturally to children by using tools that come naturally to lawyers. And so here's the question that comes naturally to children. Why do you get to make the rules? Here's the tools that come naturally to lawyers, the drawing of distinctions and the concept of a right. So the puzzle is, how is it, given that none of us presumptively gets to make rules for other people, the state, which is just a bunch of people doing a bunch of things, gets to make rules for all of us? Notice that this is a puzzle only against the background of a certain idea, which is a distinctively Kantian idea, which is the idea of external freedom. I'll say more about the idea of external freedom in what follows, but just to begin, the idea of external freedom can be summed up in the idea that no person is naturally the superior and no person is naturally the subordinate of any other person. Now, this is an idea that is so pervasive in our culture that it is not always even visible to us, but it is nonetheless striking and distinctive. Let me just briefly contrast it with the idea of natural subordinates and the idea of natural superiors. Kant says that the concept of a natural subordinate, of a being that has duties but no rights, the concept of a slave or a serf, is a concept that lacks application. Nothing could fall into that category if we think of people as fundamentally free. So too the concept of a natural superior. Kant says that the idea of a god would be the idea of a being that had rights but no duties. And he criticizes Hobbes's idea of sovereignty, the idea of the sovereign as a mortal god, as just the idea of a being with rights but no duties. And that concept too, he says, is empty, at least within experience. For us, if we start with the idea of external freedom, then the idea of a natural superior or subordinate is ruled out. But then we have a question. How can there be an artificial superior or subordinate? How is it that a public official gets to tell you what to do and force you to do as you're told? Now, in order to frame this issue properly in properly Kantian terms, I want to draw your attention to a fundamental feature of the way in which a public authority has this kind of power. And in particular, I want to draw your attention to two respects in which the exercise of this power is shot through with contingency. This is, of course, again, a completely familiar feature of human social life. The reason that elections are contested is that it matters who it is that occupies a public office. That's why we care about it. Because we know that if there is a different chancellor, or if there is a different minister of justice, or if there is a different minister of the interior or whatever, or a different majority in parliament, we will have different rules. So there is, first of all, a contingency about who gets to make the rules. Again, smaller scale. You are in a conflict with your neighbor. You take them to court. We like to think that it shouldn't depend on who the judge is that hears your case, but everyone knows that it depends who the judge is. You read the decisions of a court, even a well-run court, and you see that the judges disagree among themselves. But if they disagree among themselves, then there is a contingency of who it is that is deciding. How can it be that you are subject to a decision that would be different and yet would be still the authoritative public decision if someone else were making it? Now, I'm going to say more about the who question tomorrow. but I wanted to flag it here. But this second question is the what question. Because notice that when a public authority makes a decision, they often need to decide about something based on multiple grounds, multiple competing claims, and in particular, based on claims that seem to each assert themselves as complete and decisive, yet not all of which can be satisfied. Here is a recent example that will be unpleasantly familiar to all of you. Think about the way in which different countries around the world dealt with the recent pandemic. I'll pick just one example. There was an issue in this country and in Canada and everywhere else about school closures during the pandemic. The issue was that young children were at much lower risk of serious complications from COVID than older people were, but were very good at transmitting it. Older people were at serious risk from COVID. So what do? Because, of course, if you shut down the schools, it turns out that this is going to have learning and health and mental health implications for young children. If you don't shut down the schools, you're going to overwhelm the health system and people are going to die. Different people are going to die than would die if you close the schools. It's a hard decision. It's a decision made in circumstances of incomplete information, but if you had perfect information, that would help you, but it wouldn't make it stop being a hard decision. Because notice, you have a single public purpose, the purpose of public health, which turns out in the world in which we find ourselves to impose multiple demands, not all of which, it turns out, can be satisfied. It's not that these are somehow incommensurable. There's this large philosophical literature about incommensurability. Maybe they are, maybe they aren't. The point is that a public official is charged with doing something that a private person is not charged with doing, with making decisions that have a fundamentally aggregative aspect to them. Deciding what will our priorities be, not merely being aware that the decision will affect different people differently, but being aware that part of what you have to decide about is based on the fact that it will affect different people differently. And further, knowing that people on either side of the debate will assert absolutist positions. And yet, the public authority is charged with doing this. So, question, how can this be consistent with the idea that individual human beings are free? How is it that they can be subject to decision-making by public officials, and how can they be subject to decision-making that has this troubling aggregative aspect to it? That's the puzzle. In order to address this puzzle, I am going to use three fundamental Kantian concepts. I use three, first of all, out of Kant's fondness for the number three, but no less because it's Kant's 300th birthday year, and so for every century of Kant's life, there will be one concept that will figure in my argument. So the first of these is one I've mentioned already. That is the concept of the synthetic a priori. That is the concept of external freedom. The concept of external freedom is the idea that no one is the natural superior, no one the natural subordinate of another. The second is the concept central to Kant's critical philosophy of the synthetic a priori. Let me just say a little bit about this and why the problem of public authority is a problem about the synthetic a priori. A synthetic a priori judgment is one that connects something to something else that is distinct from it. Let me give you two examples from Kant's philosophy. The one that is important to the genealogy of Kant's philosophy is the example of cause and effect. A cause and effect are distinct things. They are not identical with each other. And so the question of causation is the question, how can one thing depend upon another thing? A synthetic a priori principle allows us to understand how there can be a kind of necessitation, one thing depending on another, with respect to a contingent matter. That is, with respect to a matter that is not already contained in the principle of necessitation. So, a cause and its effect are distinct. What we need to do is then establish the synthetic a priori principle of causality. That won't tell you what causes what. It will only tell us that we are entitled to the judgment that things happen because of other things. You want to know why, to use Kant's early example, why the house collapsed? Because the foundation was unsound. Then you need to talk to your structural engineer and figure out all of the particulars of that. But you want to know why things happen because of other things. The structural engineer is going to be of no assistance to you. Because, of course, the principle that things depend on other things is a principle we need to bring to experience rather than one that we are able to abstract. Here's a second example from the doctrine of right, the principle pacta sunt servanda, the principle that contracts are to be kept. It too is a synthetic a priori principle. Why? Because it is synthetic, because it joins discrete things. I promised you I would cut your lawn next Wednesday. Wednesday comes along, my cutting your lawn and my making the promise. There's some relation between them, but they're not the same thing. Question, what is the connection? What's the principle of connection? And in order to understand the connection, again, the principle is synthetic. It joins distinct things, but it's also a priori. It's not that we have to keep our contracts because we agreed to keep our contracts. It comes before any particular contract. Now notice that the problem of a public authority has the exact same structure of a synthetic a priori principle. It is a synthetic a priori principle because the public official telling you you must do this and you doing it are two distinct things. Lots of people tell other people what to do. And in some sense, it's just a matter of a free society that people are allowed to tell other people what to do. Except for most people, it's just advice. We need a distinctive principle that can explain how it is that my telling you to do something, or sorry, not me, I'm not a public official. A public official telling you to do something or not to do something is itself something that binds you such that you need to do it because that person said so. Now, this is, as Kant says in the opening paragraph of the Doctrine of Right, the general problem of right. He wants to know, how is positive law possible? That is, how is a contingent law, a law that could have gone a different way, consistent with everyone's freedom? The third piece of Kantian apparatus to which I'll appeal, although I'll go light on this, is Kant's concept of a deduction. The idea of a deduction is an idea that Kant takes from 18th century law. It is the idea of how we answer what the jurists call quaestio juris, the question of right, as opposed to the question of fact. I'm not going to go into a lot of detail here, but I merely want to draw your attention to the broad structure of any kind of deduction, because what I'm going to describe will be a deduction of the concept of public right. Kant does not make this explicit. He does not make it explicit. He says that the discussion of public right is easily inferred from the earlier sections. And so what I'll be doing is just helping a little in filling out that easy inference. But basic structure of a deduction, you take a principle of consistency, you show that it applies to a novel domain. The principle of consistency is just a matter of how something relates to something of the same kind, say the principles of logic. What you need to do is point, in order to explain a synthetic principle, identify the origin, the domain, and the objective validity of the synthetic principle by showing that it is a consistent extension of the underlying principle of consistency. So, in the critique of pure reason, the point of the transcendental deduction is to show that the categories of the understanding are a consistent extension of the table of judgments, which are the requirements of logic, the basic requirements of consistent thought. In the discussion of private right and the doctrine of right, the principle of consistency is the universal principle of right, which does not itself contemplate anything other than the consistency of my action with yours. And the question is, how can it be extended to such things as external objects of choice? I will pretend that I'm not merely a bailee of this bottle of water, but I'm now its owner. That means I'm entitled to exclude you from it. Not just you can't grab it out of my hand, but when I put it down, you can't take it. How is that possible? That's not just my will and your will, it's my will and your will and the object. So too, I am going to claim, with respect to understanding the idea of the public, that the relation between an authoritative determination or judgment and someone else coming under an obligation is going to require a deduction that shows it to be consistent with everyone's external freedom. Now, that's what I'm going to do. I now proceed to do so. Step number one consists in saying just a little bit more about the idea of external freedom. The idea of external freedom is, I hope, entirely familiar. As I put it before, the idea that no person is naturally in charge of another. But here's a way to think about it in terms of the way in which you get to decide about certain things and not about others. You are externally free if it is up to you, rather than anyone else, what purposes you pursue and how you go about pursuing them. Others are externally free if it is up to them, rather than you, what purposes to pursue and how to go about pursuing them. That is, external freedom is a matter of the relation between the choice of one person and the choice of another person. This idea of freedom means that there is a requirement of consistency between my action and your action, and each of us is entitled to constrain the others to behave in a way that is consistent with our own freedom. However, conversely, nobody is entitled to constrain anyone else with respect to the exercise of their own freedom. And so that means, for example, if someone is behaving in a foolish way, sadly familiar feature of human life, nobody, as a matter of external freedom, is entitled to intervene. As a free being, you are under no obligation of right to behave consistently internally, but you are under an obligation of right to behave consistently with the freedom of others. That means that you are not allowed to compel someone else to do something that is to their advantage. That means that you can at most suggest to others that they behave consistently. Decision theorists have a principle that goes by the name of the principle of dominance, which they think is a good thing, though domination we think is a bad thing. But principle of dominance says that if if one thing is better than another along all dimensions, you should choose the better thing. There is no such requirement of right on you in organizing your own life. You can behave inconsistently, you can change your own mind. That raises no issue of right. Conversely, no one has standing to compel you to behave better. So too, as a matter of right, you are not allowed to aggregate across other persons. You are not allowed to take something from one person so that another who will benefit more from it will receive it. None of those things are permissible as of right. Now notice, I've described the idea of external freedom in terms of a consistency constraint, but I can also describe it in terms of a contrast, and the contrast is important. That is a contrast between wronging someone, behaving in a way that is inconsistent with their freedom, subordinating their power of choice to your power of choice, and merely changing the context in which they exercise their freedom. If I take the nice spot on the beach, it's no longer there for you, but I haven't wronged you. I've merely changed the world in which you find yourself. So too, if I can't, these are bucolic examples for a reason soon to come. If I can't reach the apple that I want to pick off of the tree, you do not need to boost me up on your shoulders. It is up to you whether or not to do so. You do not have an obligation to provide me with a favorable context for the successful achievement of whatever purposes I've set for myself. So, if that's external freedom, notice how different this is from the kinds of powers that I described a public authority as having. Because the public authority has the power to do such things as aggregate across persons. It has the power to do such things as to require people to cooperate with each other, even if one of those people does not want to cooperate. And it has the authority to take things from someone and give them to someone else, at least under certain circumstances. And so the question is, how could this be consistent with external freedom? The key will be to provide a characterization of the way in which this distinction between wronging someone and merely failing to provide them with a favorable context can have application with respect to a public authority. So, how do we get to the idea of a public authority? I won't detain you with Kant's explanation of the transition from external freedom to the idea of acquired right, other than to note that Kant's deduction there says that acquired rights can only be valid. That is, your right to property or your right to contractual performance by another or the right to the loyalty of others with whom you stand in a status relation, that these things can only be binding in a public legal order subject to an omnilateral will. I won't go through the argument for that, but instead draw your attention to the concluding piece of it, the idea of an omnilateral will. Because a public authority is something that must be omnilateral. That is, what it is for something to be properly public is for it to be the expression not of anyone's private will, but rather instead the expression of an omnilateral will. Now, put as a contrast, the idea of an omnilateral will is both appealing and perplexing. It's appealing because, of course, the idea that you're not subject to anyone else's will, but rather to a public will, that sounds pretty good. The question, very Kantian question, of how a public will is possible is the thing that needs to be explained. What would it be for something to count as omnilateral to count as the expression of the will of everyone who is subject to it, rather than it simply being another kind of private will. So my task is to explain how this is possible. And let me just introduce two pieces of apparatus that I will use in developing the task. So the first is the idea of a public office. When we talk about the powers of the state understood as a public authority, the state is made up just of human beings. The state is what is now often called an artificial person. Kant's 18th century idiom for it is a moral person. But the basic point is that as an artificial or moral person, it can only act through natural persons. The only way the state does anything is if the Minister of Health says, close those schools or don't close those schools. The only way that the state can collect taxes is if the tax department tells every shopkeeper to add VAT to its every bill, and then through the shopkeeper actually doing it. It all operates through natural persons. However, in order for the public to exist, I will suggest what you need to understand. You need to understand it as a system of public offices. So, second piece, the idea of a public office, I'll suggest, carries with it also the idea of a mandate. Every public office has an official mandate that it is required to carry out and not permitted to exceed. If we can fill out those ideas, we will get a characterization of the distinctively public standpoint as properly omnilateral, as preventing any kind of exercise of wrongful private choice. So that's the plan. And let me just give you a preview of the picture with which we will conclude. It is a picture on which the fundamental difference between a public authority and a private person is this. As a private person, you can do whatever you want, and unless you are expressly prohibited from doing it. A public official is not allowed to do anything at all unless expressly permitted to do it. These two together will give us a picture on which our distinction between wronging someone and merely failing to provide them with their most favorable context for their particular purposes will have application. So, how do we understand this idea of an omnilateral or a public will? I want to introduce it in more detail by considering a challenge to the idea of an omnilateral will put forward by Nico Kolodny in his recent book, The Pecking Order. Kolodny says that the idea of a public will sounds very appealing, but it turns out to be mysterious because he puts his argument in the form of a dilemma. Either a public will means just a non-private will, in which case it seems its distinctiveness is lost. That is, it seems to be just as willful. Why should anyone care, if they have an interest in not standing in hierarchical relations, whether they are subject to a private will or a public will? They're both wills, seems to be no improvement. Alternatively, Kolodny says, the idea of a public will might be understood not in terms of a formal contrast, but rather substantively. That is, a public will would be one that was charged with preventing people from standing in hierarchical relations. The problem with the second possibility, according to Kolodny, is that this second possibility would seem to be unable to explain why any of this is relevant to politics or to public institutions at all. As he puts it in a particularly striking way, even a kindly slave owner could do that task for a group of slaves. The kindly slave owner could protect the slaves from dominating each other. It seems like it would still be slavery, yet, so he contends, the Kantian idea of the public doesn't give us the resources with which to understand what's wrong with it. So, like many arguments put in the form of dilemmas, Kolodny's argument actually fails to recognize that the possibilities entertained are not, in fact, exhaustive. The way to see that they're not exhaustive is already contained in his example of the kindly slave owner. Because, first of all, a slave owner, although morally impossible, is, of course, factually possible, but only institutionally. A slave owner is an institutional role within an unjust system of institutions. But if that is the case, then he has not actually moved away from the institutional. But here's another problem. We can fix that problem by saying, well, suppose it's not a slave owner, but rather a warlord or a criminal gang leader. These are people who have unlimited power, and Kolodny asks us to imagine they could, if they so chose, use that power to simply protect people from each other. And so simply use it, intervening only to prevent domination. Now, what would be wrong with that? Here's what would be wrong with it. Again, the modifier kindly masks the fact that it both masks and reveals the fact that the imagined slave owner, warlord, or gang leader actually has discretion with respect to whether to provide for protection against domination. It is a purely discretionary decision, and the problem of public right is the problem of finding a characterization of a form of association in which nobody has discretion over anyone else. And how do we protect against that? And the answer is through the idea of a mandate of a public official. Notice, if you have a public official who has a mandate, then the public official is not, it in one sense has discretion and in another sense does not. Think back to the Minister of Health in dealing with the pandemic. The Minister of Health has discretion with respect to how to compare and combine the various claims being made. The job of the Minister of Health is hard. They both need to gather expert evidence insofar as it's available about the likely consequences of various courses of action. But no less significantly than that, needs to decide how much weight to attach to various courses of action. To say that the person has discretion is not to say that there are not better and worse answers. It's not to say that there are not better and worse exercises of that discretion. It is to say instead that in order to be acting within the proper terms of the mandate, the Minister of Health can decide more than one way without violating it. It's not that there is no fact of the matter about the ideal course of action. I'm not saying that there is a fact of the matter. I'm just not saying that it depends on there being no correct answer. There could be a correct answer. There may be no correct answer. But the question of whether the Minister of Health is acting in accordance with the official mandate does not depend on whether they get it correct. If there is a correct answer, it depends only on whether they are acting within that mandate. But now notice, once we talk about acting within a mandate, we then have the resources to draw the following distinction between acting within a mandate and exceeding that mandate. To exceed the mandate, we might describe as privatizing the public office, using it for an improper purpose. I'll have more to say about improper purposes in a minute, but the basic thought is that there are multiple things that might be considered, and there are certain things that must not be considered. We have a word for an official who considers the wrong kinds of things. We call that official corrupt. What does corruption consist in? Corruption consists in using a public mandate for an improper, which is to say, a private purpose. If you use it if the official, sorry about speaking in the second person here, if the official uses it for an improper purpose, they act corruptly. And the nature of their wrong is, and here I'm going to use more Kantian vocabulary, which might sound extreme, but I mean it. It is not necessarily a wrong against someone in particular, though it will often be, but it is, to use Kant's idiom, wrong in the highest degree. It's wrong in the highest degree because it is inconsistent with the possibility of rightful relations. Kant's other examples of things that are wrong in the highest degree include false surrender in wartime, counterfeiting, and revolution. Now, you might think that, say, the customs official accepting a bribe, it's kind of overblown to describe that as on a par with a false surrender in wartime. And again, crucially, we can talk about degrees of seriousness, but in characterizing the nature of the wrong is that it is acting on a principle that is inconsistent with the very possibility of a public office, and so inconsistent with the very possibility of a public legal order. It turns a public legal order into a tool for the achievement of private purposes, and so is for that reason wrongful. But now we have the concept of a public office that characterizes it by contrast with its characteristic pathology, the way in which it can go distinctively wrong. We see why Kolodny's example of the kindly slave owner does not count as a public authority, precisely because, given that the slave owner, as imagined, has unfettered discretion with respect to what is done with the slaves, this is just the option this slave owner happens to have selected. Therefore, we can't talk about the distinction between corrupt and non-corrupt. Because, of course, the slave owner occupies a role that is inconsistent with right as such. It's not a role that anyone could rightfully occupy. And so it doesn't matter at this stage of the argument how someone who comes to factually exercise such powers actually exercises them. The problem with their wrongful exercise is precisely that it is wrongful as such. It could not be a rightful form of organization. This is, of course, of a piece with the more general Kantian emphasis on the possible over the actual. The fact that someone abuses their office is a wrong in the particular case, but in assessing which offices can be rightful, the ones that are possibly consistent with freedom if someone acts in accordance with their mandate are possibly rightful, And then there is the question of whether the exercise of the mandate is rightful. So I've put all of this in terms of offices and mandates, and I want to just digress for a moment to emphasize that this is a structure of argument that applies only with respect to public right. And in particular, I want to distinguish it from two lines of argument that are familiar in the 20th century and 21st century philosophical literature, superficially similar and fundamentally different. The first of these is the idea of associative obligations, developed by Ronald Dworkin in his book Law's Empire. He suggests that somehow if people engage in a cooperative activity together, they come to owe obligations to each other. And then he wants to say, see, the state is just a special case of that. The other is the idea of a role obligation, that by voluntarily undertaking a role, you come to have obligations to those who come to depend on you carrying out that role. The problem with both of those arguments is that neither of them treats the state as distinctive. And in fact, associative obligations and obligations, or so-called associative obligations, and so-called obligations voluntarily undertaken on which others come to depend, are only as good as the cooperative activities in which the associates are engaged. The fact that the members of a criminal syndicate have come to depend on each other, the fact that the kingpin of the criminal syndicate has voluntarily undertaken a particular role, has no moral significance whatsoever. The problem with those kinds of analyses is that they attempt to take concepts of general application, concepts that are in fact concepts of private right, and try to generate novel concepts that will apply to public right. But the Kantian view denies that. And in fact, an association can only impose binding terms on its members, can only generate genuine obligations under the idea of public right. The idea of public right is more fundamental. So, if that's our picture, then we can see how a public official acts properly publicly if they act within their mandate. We can also see that the only way, given that acting within your mandate is acting as expressly authorized, that there can be a public mandate for a particular official is as a member of a system of public mandates for multiple officials. That is, it's not a matter of an individual transaction. It's not that this person decides about this matter. It's rather that this person's task is within the broader system in which this mandate has been conferred on them. So this requires that we have an understanding of the public as a system of offices, a system in which each office has a specific mandate as given to it by another office that is one level up. At no stage in the formulation of any of those mandates, because every mandate, including the mandate to determine someone else's mandate, is governed by the requirements of an omnilateral will, which is to say, no one is allowed to exercise their mandate for a private purpose. If we have a hierarchy of offices, at the top of the system of offices, all we have is the purpose of creating a rightful condition. If that's the highest order office, then of course it has to be differentiated into more specific offices. And so, just as an example, the government sets out a series of ministries. Within each ministry, there are people charged with various decisions within each ministry. They then delegate powers to others lower down in the system. So too with respect to the judiciary. The judiciary is charged with resolving disputes, and so they resolve them in accordance with the law as passed by the legislature. But the legislature is charged with determining the law, again, subject to the distinctively public purpose of providing a rightful condition rather than for any private purpose in particular. Now, you might at this point wonder whether the account as I've given it is excessively formal. It's a Kantian account, and so, of course, it might seem to be, to some of us, a virtue to be formal, and indeed, the idea of excessive formality might seem like a puzzling challenge. But here's the two-part response to that concern. The first part of the response is, of course it's formal, because what I want to explain is the way in which the most general principle of external freedom, and thus the most general principle of right, the idea of the consistency of one person's choice with everyone else's choice, can be applied to a public authority who is allowed to make judgments that are discretionary in the sense that I have described, and further, that in order to understand that, we have to understand how the distinction between wronging someone and merely failing to provide them with a favorable context could have application to that case. And the answer is, it could have application through the distinction between acting within a mandate and exceeding the mandate. And that means that a public official charged with making a difficult decision can, in fact, make a decision that will be really bad for some people. And that it is really bad for some people is something to be regretted and something to be considered in making the decision. But nonetheless, it could be that without, as such, being a wrong against those people. By contrast, if the public official behaves corruptly, it is wrong in the highest degree and maybe a wrong against someone in particular. So that's the first part of the response. Of course, it's formal. It's synthetic a priori because it explains how the decision of the official and the norm governing the individual, and thus the act of the individual of complying with the norm, are connected to each other through a general principle that shows that it is consistent with freedom in general. So, second part, it shows that the particular office that a person occupies limits the public grounds that they can consider. I have lots of examples of this, but let me just mention one. In England, the Bank of England is the regulator of financial institutions. And some years ago, it declined to shut down this corrupt bank called the Bank of Credit and Commerce International. Those of you who are my age will remember it was in the news because it funded all of the international scandals of the 1990s. It was how the drug cartels laundered their money. It was how the Iran-Contra deal was worked out. All of this was this bank, and it was corrupt. And the Bank of England didn't shut it down because they worried it would create a financial crisis. Of course, it turns out that it was so corrupt that it collapsed on its own and provoked a bigger financial crisis. So, question. They were acting for a proper public purpose. They were trying to prevent a financial crisis, but that wasn't in their mandate. And so it counts as corrupt. Different example. I'll limit myself to two. There was another English case in which the police declined to deport a convicted murderer on the grounds that he was a police informant. Now, having police informants, kind of distasteful perhaps, but it's proper public purpose. Crime prevention, proper public purpose. Minister of Immigration, not their job. Not within the mandate. You need a system of mandates, and the mandates need to be differentiated. Now, you might think that these examples then just push the question back because you want to know which mandates are they. And here, I'm going to give a schematic answer and give more of an answer tomorrow. The schematic answer is that determining which mandates they are requires what Kant, in his notorious late essay on a supposed right to lie from philanthropy, calls a principle of politics drawn from empirical cognition. Which mandates they are depend on the particulars of the society and the particulars of the human beings making it up. Let me return yet again to the example of public health. In the case of public health, the fact that there are vulnerabilities of the human body that can be prevented, and that there are vulnerabilities of the human body that can be treated, is utterly contingent. And that there are is something with which a public authority needs to deal. So too, the fact that states sometimes attack other states, do so with alarming frequency these days, that is in some sense contingent from the point of view of right, and nonetheless something with which a public authority needs to deal, the threat of invasion. So too, with various other things, the fact that economies grow in some ways and not others. These are all contingent matters. So, notice, these are the kind of contingent matter with respect to which the synthetic a priori principle, the distinction between acting within and beyond a mandate, operates. The distinction between acting within and beyond a mandate applies to the matter of human social life in a particular historical period. The synthetic a priori principle shows how those things can be brought into conformity with the requirements of freedom. They show how those can be so brought into conformity even though more than one answer is consistent with freedom. There's this picture of Kantian philosophy that imagines it to be a competitor with utilitarianism, that is, a complete answer to every imaginable question. And all we need to do is consult the expert, the philosopher, who will tell us what to do. That's not how it works. Instead, all that philosophy can do is give us the synthetic a priori principles we need to understand how, in this case, the public office is possible, that is, how it can be consistent with the freedom of everyone. Now, I began with two questions about public authorities. The what question, that is, the contingency of what is decided, and the who question, the decision about who it is that gets to make the decision. I've said nothing about the who question, but I give you that is my question for tomorrow, and the preview of my answer for tomorrow to the who question is that we give the laws to ourselves. I'll tell you more about that tomorrow. Thank you.